Welcome, everybody, to this Warden webinar where we're going to be talking about the Eightfold lawsuit that came onto our radar just about 2 weeks ago now. I'm Martin Redstone. I'm head of responsible AI for Warden and industry engagement. I'm going to be your host today. Most of the time, I'm on the other side of the table as a guest, so it's going to be great to host rather than participate actively. Joining me today, we've got Julie Sowash, we've got Hung Lee, and we've got Jeff Pohl as well from Warden. I'll let them introduce themselves one at a time so you can get to know our guest speakers today. Julie, why don't we start with you?
Thank you guys again for having me. I'm super excited to be here. My name is Julie Sowash. I am the CEO and co-founder of Catch-22 Group, and I am also the newly minted for about a year job board doctor. My prior life is really in OFCCP compliance, affirmative action, and I helped co-found and build the world's largest, basically RPO for people with disabilities in the world. So again, happy to be here and happy to be part of the conversation.
Yeah, thanks. I really can't wait to hear your take on all of this as well. Thanks, Julie. Hung, why don't we go to you next?
Hi everyone, my name is Hung Lee. I still think I'm clinging on to the identity of being a recruiter, guys. I'm still there, right? I'm still thinking I'm a recruiter. I did send a CV recently, I have to say, so I'm still in it. These days, I write a newsletter, I curate a community. I basically try and help conversations flow in the ecosystem. I think it's very important that we all kind of stake our claim in the public discourse. So yeah, I try to support that.
Excellent. Thank you very much. I'm really looking forward to your take on this as well. I know we already had another webinar earlier today, the two of us, but a slightly different conversation this time, which would be great. Jeff, on to you. Why don't you introduce us as the sponsor of this event and give us a little bit of a background on Warden as well?
Sure. Hi, everyone. Good to be here. My name is Jeff Pohl. I'm the co-founder and CEO of Warden AI. My background before this was in building AI systems, particularly in regulation technology. Warden, we help bring trust and transparency to AI systems, specifically within HR and particularly recruitment technology, by doing third-party auditing and monitoring of those types of systems. So this case is obviously really aligned with some of those principles around trust and transparency. So excited to be unpacking that today.
Fantastic. Thank you so much, Jeff. We're here to talk about the Eightfold class action suite. We're here to talk about the FCRA, privacy, fairness, all of those kind of things. 2 weeks ago, hit the newswire that Eightfold were being taken to court in a class action suit in California for allegedly being some kind of credit rating agency. The crux of that case is that they are collecting profile data of people who may not even be applying for jobs, creating a massive database of profiles through scraping data like LinkedIn, GitHub, and all those kind of things. And the crux of the case is that people don't know that that's happening. So, they're having their data collected without their consent. They being Eightfold are selling that data onto their clients, employers, who are then making a hiring decision or even an outreach decision based on that profile. So that's my take on it in terms of setting up what's actually going on the lawsuit side of things. Before we get into the actual conversation, just want to let everyone know the chat is open. If you've got any questions for the panel, please use that area there. At the same time, it can be very difficult to monitor a really high energy chat feed and have a great conversation at the same time. So let's try and keep everything on point. Please do ask your questions as we're going, and we'll try and get around to them as much as we can towards the end. I'm going to come to you first. We were talking about this a little bit earlier on today. Why has the industry relied on public data for such a long time?
Well, I think, to be honest with you, this is just the latest episode of where technology innovation is just kind of been so far ahead of not only legislation, but also kind of public consciousness to a degree. If we rewind back 10 years or so ago, there was the wow factor of products then was these people aggregators that were emerging, gathering social information, aggregating a profile and providing a search interface for recruiters. And it was brilliant. I mean, I was a recruiter. I saw these products. I thought, wow, that's amazing. Never seen the like of it. This is going to make a huge difference in my work. And these were very effective products. What we didn't know then was anything like, okay, who owns the data? Do any of these platforms have the right to aggregate your profile in this way? Do they have the right to sort rank the results in this way. This was even pre-disparate impact. So I guess what I'm trying to say is that the technology is always ahead. This is kind of just another iteration of it. It shouldn't surprise us that we're getting this legal catch-up going on. I'm not sure either way what is good or bad. I find it difficult to moralize one way or the other. I think all of us would agree that we don't want to have unjust outcomes. I think most people that are not psychopathic would generally say, no, we want fairness. We just have a different version of what fairness is. I think that, I'm not sure we get there with legislation to get fairness, to be honest with you. But at the same time, I don't think we get there by having a free-for-all either. So I'm happy to engage in debate. I'm happy to understand sort of a little bit more about what I don't understand. Let's get into it. But yeah, this is just something that I think is going to be kind of continuous, because what we see now with technology innovation is that the cycle speed is faster. Technology innovation is getting faster and faster, such that legislation will always be behind. So we have to get used to having conversations of this type.
Yeah, absolutely. You make a really good point. The speed of legislature decision-making process in any government, doesn't matter where they are in the world, tends to be a lot slower than the way that innovation's going. So it's a fantastic point. There was a question already asked on the chat about whether people think that because AI regulation is so messy at the minute in the USA and all the different things that are going on there, whether they chose this route of a 1970s piece of regulation to go after this case with, because ultimately AI regulation is such a mess. So it just shows that regulation and innovation are really not balanced very well. Absolutely. But that kind of takes me on to the next point. And Jeff, maybe I can come to you on this, because while Hung's talking about the fact that legislation and innovation are kind of at sorts with one another and not catching up, there's already been a legal case around a very similar subject. Do you want to talk to us a little bit about...
Absolutely. One thing that's a bit different about AI, I think, than some types of technology is that there are some additional regulation needed, and we're seeing that in US and state and otherwise regulation. But actually, because AI either substitutes or augments human processes so often, we actually already have like a massive network or ecosystem of regulation, tens of thousands of them, that apply to human-based processes. And to some extent, we don't necessarily really need the new AI ones. We need to uphold AI to those human ones. And that's kind of what we're seeing in litigation in this case. Again, it's an older law, as was Workday versus Mobley. And so yeah, just kind of a side point on that front. In terms of the precedent here, there's one not super well known around talent bin, Hal versus talent bin in, I think, 2015 to sort of 2017, in which, as I understand it, they were doing something quite similar, where they were using public, well, at least the allegation was that they were using public social media profiles, aggregating those about passive candidates, not applicants, and selling that information on to employers to, choose who to outreach to, etc. So it was a class action lawsuit. It ended up being settled for, I think, $1.15 million. So it didn't become like full case law with like a full ruling from the court to refer to as a case law precedent, but it's obviously made traction. And the main kind of allegation in that was the Fair Credit Reporting Act in the FCRA and violating the requirements to give notices to consumers that are being part of a process like that. Quite interesting parallel to Eightfold case. One thing that in my head is, without knowing Eightfold in great depth, that might be different here is I'm not sure the extent to which the Eightfold case is about passive candidates or active candidates. Like a feeling is that maybe it's a bit more these people have explicitly applied. There were not applicants at all. It was just anyone was fair game to create this information, not maybe 100% parallel.
Yeah, I think it gives a good indication of potentially what might come of this case. I noticed when I was having a look at the settlement that there was some operational impacts as well. Do you want to take us through what they were? Rather than, obviously there was the $1.15 million settlement, but there was also some operational impacts that were pushed onto Talent Bin at the time. And I think that might be a good kind of indicator of what there might be expectations on Eightfold as well. Do you want to take us through what they were? Yeah, no, absolutely. So I just got the link put into the chat as well. So for anyone that wants to actually have a look at the settlement PDF, but I just brought it up in front of me. Talent Bin agreed to revising terms of use between Talent Bin and its potential employer and recruiter users, enhancing the ability for individuals to correct the candidate profiles about them, system enhancements that improve the recency of information in the Talent Bin profile upon request, an enhanced mechanism to assist Talent Bin in removing profiles from their system, and an enhanced list of terms that Talent Bin will exclude from candidate profiles. So I think that kind of comes down to, again, When we think about some of these things, we think about current regulation. You think about GDPR, there's a lot in there that kind of circulates around GDPR, keeping data up to date, giving people a way of updating their data, deleting their data, opting out, making sure that the recency of the data, it's all very kind of GDPR-esque. So I think that's something that we need to think about. And anybody that's thinking about building in this space has to look at what's happened in the past in order to plan for the future. Julie, when we were first talking about this session today, you mentioned something really interesting, and it goes back to the litigation as well in the court case, is that, and somebody said there's such a mess of regulation going on right now in the US. So do you think this is what we're going to be seeing more of?
I think really what got me thinking about this point, Marty, is that over the past week or so since the complaint was filed, I've heard so many comments from TA tech leaders, vendors mostly, that they shouldn't be concerned about the Eightfold class action because it's what they defined as activist litigation, mainly due to the specific attorney and the law firm representing the plaintiffs in this case. And the emphasis being on the negative inference of activism or activist. And my response to that is that the US has a long history of litigation focused on removal of infringement of rights for certain classes of people. And in this case, it's job seeker as a class. And this is especially true when we're in environments like this, where the other branches of government at a federal level are not working in what someone deems an appropriate speed or manner towards protecting that class of people. We can see that, especially in the labor movement, whether it's legalizing unions, collective bargaining, minimum wage, all of those things around health and safety and how we work here in America came through what we would term activist litigation. And so we are going to see that the corporations are not going to act as in the best interest of this class. And when we have now a legislative branch with 2 sessions of Congress who've been unable to pass even one small AI regulatory or enforcement bill, let alone comprehensive legislation, and then an executive branch on the other side who has gutted so many executive orders that are civil rights era, affirmative action, employee protections, pregnancy protections. I can go on forever. We have to know that this is going to come, and that plaintiffs' attorneys are keeping their eye out of where they can use, to Jeff's point, existing legislation to provide protections in what is now the wild, wild west of the AI era. And so this is not going to be the last, and it should really concern employers because it can put employers on the hook for quite a bit of money that's outside of just an EEO settlement or some kind of regulatory enforcement. And employers, just like we as job seekers, don't want the legislation from the bench. We want comprehensive enforcement, comprehensive legislation. And so, to Tim's point, I love this question that you ask. President Trump signed an executive order that says, hey, AI can't overstep certain parameters at the state level. And do I think that the reason that they're bringing this case against Eightfold as an FCRA case, a Fair Credit Reporting Act case, is because of that executive order? My answer would be yes and no. I think that for the most part, those state level AI cases or laws have gone into effect, and there's not been any court action yet with the administration trying to stop the enforcement of those. But to Marty and Jeff's point earlier, what I think that they are doing with using this as an FCR complaint is potentially opening Pandora's box of information that can lead to very strong bias, affirmative action, and other class complaints. And so by using the existing legislation and saying, hey, we may have been discriminated against, we may have been impacted by the scoring process, not because I'm a female or because I'm a person with a disability, then that becomes the grounds for so much more. And so that's really where we're at, is how do we know what's going to come out of this? We don't. And that's what Chad and I have been talking about a lot this week. This FCRA opens Pandora's box of data.
What did you find when you were looking a bit deeper into it?
The patent itself is really written like they expected Eightfold to be at some point a consumer agency. Even the language that they use in the patents, the language that they use in their privacy terms and conditions is so on point to the legislation of the FCRA that they had to know something like this could come, or they expected that they were going to expand their TAM at some point outside of employment potentially. I think the other thing that really jumps out to me is the inference of data. Just as a person who is highly focused on fairness and quality, I see things like quality of education, location, a lot of things that say I can infer redlining nearly by using quality of education as a rank, by using location as an indicator. If I know that certain groups of people are not progressing to those more senior job skills or job titles, then we can assume that there may be bias that's happening. So really just that, what we're inferring, and obviously the black box of not even know what public data is actually being used, that there's just going to be a free for all if this case gets to discovery.
Yeah. And just to clarify, so it's a question that's been asked on the chat as well, going back to one of Jeff's points, which is about whether it's passive or active job seekers that the profiles are being built on. My understanding from the case is that people are having profiles built on them who aren't active applications into client companies of Eightfold. Is that what your understanding of the case is as well?
Yes, according to their marketing, 1.5 billion talent profiles. And so that's going to include employees at the companies that they work with, unqualified candidates from the employers that they worked with, including disposition data, which is something that caught my attention today, as well as other publicly sourced assumed passive candidates. So I think Jeremy Roberts put a good question out to LinkedIn this week is, does it matter if it's an applicant or not? And I think the court will have to make some decision about that. But there is a lot of overlap between Talent Bin and Eightfold that Eightfold probably could have taken some learnings from, but still, I think fundamentally different core groups.
Yeah, it can be. So just like yourself, I've had a lot of TA Tech and ATAR Tech vendors contacting me to ask for my opinion, asking about what they do with product plans and all the things. And one of the conversations that I'm hearing very much across the space, and Hung, I'll probably come to you on this as well, is this kind of concern around market overcorrection versus ignoring the risk ultimately. We had this kind of conversation earlier today as well, which is AI kind of bringing into the world this mindset of not worrying too much about data privacy. What are you hearing in the market after this whole April thing?
I think it's one of these where it just constantly begs ever bigger questions. If you think about AI in general, large language models, generally speaking, they've been trained on tons of data that no one gave any consent to, and no one gave any consultation on, and certainly very few people were comped on. I mean, I don't know how much was the settlement that Anthropic recently signed with something like a couple of billion or whatever it was. So there's ongoing concerns that maybe the entire edifice has been built on IP that the AI companies didn't acquire consent on. The argument that the AI companies have, and I've got plenty of sympathy for this, is that, hang on, if we just spent all our time asking for consent on every single thing, we wouldn't even have these tools right now. Isn't that just a huge backward retrograde step? Isn't that just the exact example of regulation strangling innovation? And we have seen some absolutely material advancements in things like drug testing and gene therapy, things that are obviously good for mankind, that has resulted from the experimentation on the edge by some of these companies. So I don't think it's a simple case of big tech bad, even though, big tech bad is generally sort of something you can reliably say. But in this case, I think we have to have a nuanced view on it. What vendors are saying, different things. I think vendors typically are quite gung-ho. If you know your software entrepreneur, they're going to build it first and then see what happens. And that's what happened in that previous iteration with the people aggregators. They built it first, seen what happened, and generally speaking, a lot of them got away with it. I do suspect that's still the current sort of sentiment amongst the recruitment technology vendors. It's like, you know what? We can't build according to the legislation or predicting what it is. Let's build it. Let's see if someone gets sued, and then we'll see then what happens. And hopefully we're not the one that's getting sued and we'll dodge it. So I think that's basically where the software tech community is right now.
I suppose the thing with Eightfold is obviously, they're one of the big unicorns of the industry. They've seen meteoric rise over the last decade. Do you think if there's a court-ordered correction on Eightfold, that's going to see a complete market overcorrection on the vast majority of these tools?
No, I'm going to have to bring Trump into this. I mean, Tim did mention it, but I don't think Trump allows it. I think he will simply, that there is basically, Cartman is in charge of the White House. This is my view of it, right? So literally, we're in South Park timeline here. And what's going to happen is that this guy is going to get lobbied by the big tech companies, and he's going to say, no, that ain't happening. And he's going to roll it out over the top. And I think basically a lot of these companies will probably survive based on the relationships they have politically to get them through it. That's the cynical take, but you know what? With cynical times, this is where I see it going.
And I think that you're 100% right. Sorry, Marty, that's exactly what's happening. In America, administrations change every 4 years. And so it is short-sighted for especially startup and up and coming tech to be thinking with such a short-term lens. And I'm not saying they won't, because I think that they probably will. I think you're absolutely right. And they'll try to skate for as long as they can, but the taxes will come due eventually. It's how much money can they make in the meantime?
Yeah, to chime in on this point, challenge it a little bit. I think there's a number of different forces at play, and the administration is not the only one. And I think, like, obviously people, the compliance catches up for the technology, as we said at the start, and that comes from a mixture of things, right? It comes from regulations, which we do have happening. We have litigation on old regulations, which is happening. Again, how much it plays out or not, it's not going to completely go away. And the third thing, partly connected to these two, is we have buyer pressure on the vendors. And that's the thing that we see has consistently gone up over the last few years around looking into AI tools, even with the caveats of Trump administration maybe trying to take a less severe stance. We have still seen an increase in that scrutiny overall because there's so many risk factors. So there's still the risk of lawsuit as an employer, etc. So the rate of change in terms of the rate of correction might be different based on that, but it's hard to imagine a world in which we are not at least gradually stepping towards more mitigation of the risks of AI, to put it in abstract terms.
And it's a superb point on the buyer side of things, and it was why I wanted to come on to next, because I know a lot of our audience are in that position rather than the vendor position. So that was kind of where I was going to go to next, really, is what you think that kind of operational risk is from a buyer perspective. We talk a lot about vendors and they might have to correct what they're doing, but where's the sentiment on the buyers? We talked about this earlier again today in terms of buyers wanting to make sure that their supply chain is responsible, ethical, etc. Do we think that's going to force that pressure as well?
So I think, we're seeing that the first level is vendor, right? They're the ones developing these tools. Buyers obviously want to put in the effort to mitigate the risk on their own side, by and large. And so they push that onto vendors more and more in terms of doing audits, monitoring, even the FCRA stuff, I imagine will be what can the vendor do, if anything, to make sure they're not violating it. But over time, given that this is AI that's kind of replacing humans, as we said, it's not about AI regulation, it's about human regulation in many cases. And those regulations apply to the deployer of the AI, the employer. I think it is unavoidable that will start to happen. And we're again seeing that start to happen a bit more. So I think this could be a realistic case for accelerating that, because this would, a lot of obligations here are actually on the employer to provide the notices to the candidates rather than the vendor. The whole vendor might facilitate that, but it would ultimately probably be the employer that's doing it. So this could be one of those kind of catalysts for that change.
Fantastic. And Julie, I suppose from your side, you're very much on the buyer side of things as well in terms of the RPO that you run. What are you hearing from the buyer side of things on this?
So a few different things. A lot of well-intentioned buyers who don't have the technical and operational experience and knowledge to be able to differentiate sales pitch from reality. I think that is a huge issue. I think there is a toned down fervor since the administration changed on governance, which again, I think is a short-term shareholder earnings type response that will come back into play. I think sometimes companies are getting a little too complacent with the terms AI and the actual impact that we see. For example, I've done a lot of writing about Indeed over the past couple of months, and we're seeing them put AI tools in place that are charged at the per job level, which means that due diligence that our corporate attorneys need to do is probably not happening because we have put it on our corporate card, or we've had this existing standing relationship with Indeed in this case for a long time. I think the last thing is that we just really need to provide the right tools and education for these buyers to be able to know when it needs to go to legal, and that ultimately under the law in the United States, they are still responsible for hiring decisions. And so while these cases, Mobley, Eightfold, are completely unique in that they are starting to potentially hold vendors accountable for decisions that they are making on behalf of the employers, right now the law is very clear. Hiring decisions and whatever those outcomes are completely owned by the employer and not the vendor. So I think they really have to continue to think with their risk hat on, with still being able to make positive impact. Like, I'm not a throw AI in the ditch kind of person. I am an AI optimist. I think we can do really, really great things if we have the right governance in place. And so I hope that that's really what companies are thinking about.
So back to you on this, Hung, from an operational recruitment perspective. I know you like to think that you're still a recruiter, so we'll come to you on this one. Who owns that part of the process? Who really should be the person that is ensuring that, what they're doing is ethical, is responsible? Who's questioning their supply chain, their vendors, their suppliers on how they're doing things, where they're getting data from?
I mean, the obvious answer is head of function, right? This is a, just another sort of thing that's going to slow AI adoption down within the TA and HR function. I think we've already been fairly kind of compliance driven and risk averse when it compared to other functions, let's say. I mean, if you imagine something like sales, I think sales is pretty much just push the button and go. In fact, a lot of the issues when it comes down to aggregated social data and so on is totally applicable to sales. But they've gone ahead and play with it, and Clay's a $1 trillion business or whatever it might be. So the bottom line is, I think this just causes more slowdown. But again, we come down to this Scylla and Charybdis situation with TA because they're getting pressure from the top to move faster. And then they're getting pressure from the outside to move slower. Something's going to break. And almost like a fork in the road. Dividing line between the personalities of the TA heads that are just basically saying, stuff it, we're going to go. And press the button on, I think, fairly high risk activities and initiatives. And then you have the other side that is fairly conservative and saying, actually, we've got to keep pausing. And we're going to have kind of two types of cultures of using AI, I think. What does that lead us to? I don't know. I guess we might see some outrageous competitive advantage from the people that take the risk, but maybe they get hold in the ground by taking those risks. But maybe the slow movers themselves incur a risk of a different sort with general inefficiency or simply being replaced in job by someone who's prepared to take those risks. So yeah, TA's in a bit of a vice-like grip. It's not comfortable for us right now.
No, and I don't think it has been for a while with everything going on. But actually, you raised a really good point around how we're very high risk in TA. We're in a bit of a mess. It's going to slow down AI adoption. You mentioned about sales and marketing. One of the things that dropped into my inbox this morning was an email from Lucia, the email and telephone lookup tool. That email was very much, I think it was just a masterclass in how to deal with this kind of collecting of profile data. The email came out of nowhere, came out of the blue. It said, hey, we've captured your data. We'd just like to know we're adding you to our database. I got one from Apollo last week as well. It's incredible. You start a new job and literally within a few weeks, you're being kind of put into an email sequence somewhere. We've captured your data. This is the data we've captured. Here's the kind of data we tend to hold on people. You've got 14 days to reply to us to say, you can opt out of this. Here's where we got all the data from it. And so it was really quite clear. So I wonder whether we're overthinking this as an industry and thinking actually there's really good practice going on elsewhere. And there's solutions for how we can manage this as an industry. So I actually probably come to Jeff on this a little bit. So thinking about how this kind of going back to the lawsuit, it's all about creating this kind of shadow dossier, this profile on people, and why that happens to be a bit of a consumer risk.
So, well, I think in terms of solving it, the main thing is in this particular law, right, is the notice or lack of notice. I think there's two options: either stop doing the shadow dossier, going off and getting information that it's not aware, or make it explicit to the candidate that's happening. Pros and cons to that, but by and large, it could be that it's quite a simple notice and candidates accept that's how we're applying for a job and it's not that big a deal. Playing devil's advocate there, it could be that, okay, there's explicit notice about that happening. You're explicitly telling candidates that AI is being used. Does that invite more AI lawsuits around bias, for example? Possibly. I think macro, this, I understand it could be solved relatively simply with candidate notices. I think what's more interesting is this is just part of a trend of transparency. So you think of transparency, you've got just people being aware in the first place that, for example, information is getting collected about them or an AI is being used to judge them. But some of the AI laws, and someone mentioned the CCPA ADMT amendments, interestingly, go further about the level of information that consumers should be provided with about an AI used in decision making, in terms of if they get a negative outcome, explaining exactly why. And that is a higher bar of transparency, which I think we're, as an industry, going to be stepping towards that over time. But the actual FCRA ones, like being a true expert, I'm not sure that it would be that complicated to put in the notices in place, to be honest.
But when we think about how we're going to start creating these defensible strategies as both buyers and both vendors. Come back to you, Julie, a little bit, because I know you're on both sides of that divide. How does one work without the other? Can we have fairness? Can we have legality? Can we have privacy? Does it all work together?
Yeah, I mean, I think we can't have one without the other. And one question that I've kind of been asking myself this week, kind of related to what Jeff just said and leading into your question, Marty, is if I, as a consumer, in this case, a job seeker, am able to get a notice that this information has been collected about me, I should have a right then to dispute any incorrections. But how do we dispute inferences? I think that's the big question, because that's what the score is based on. And it's not a clear definition of what that score is or how that score is reached. And so we really have a lot of potential opportunities for risk there. But the consent is the first part, and then the correction. But then how do we show inferences? How do we show that score and make sure that consumers, in this case, job seekers, have the ability to do that? And when we're thinking about what employers should be doing, we should have real-time auditing. And that's really the only way I think that this works in terms of a fairness perspective. For example, if we go back to Eightfold, they did a self-audit of 2024 data for the New York City law, which covered only race and gender, which is inadequate from my perspective on how the groups that could be impacted. And they did it as self-report. So we're 13 months behind in the data. It was a self-report tool. It was limited in its scope. It met the parameters of the New York law, but it doesn't really meet the parameters of understanding that we need to be ensuring that we're screening candidates in and not screening them out. I think the only way we can do that is to have real-time governance and a very strict, I'm not great, consent and privacy are not my cup of tea, but we have to have absolute transparency, and people have a right to own their data, whether they put it out there publicly or not. I know that's controversial, but they should have the right to see it where it's impacting their lives and their livelihood.
Yeah, I couldn't agree more. So I suppose that kind of gets us on to the how do we actually implement that kind of process? The auditing, the consent, the explainability, the transparency. Hung, I know we were talking about this a little bit earlier today. So why don't we come back to you a little bit around how we can implement responsibility and ethics in the TA process? It'd be interesting to hear your thoughts on that.
I'm not particularly good at solutions on this topic, mate. I think this is just a sticky toffee. I think you can go a long way by accepting that it may not be a case where there's going to be perfection. I think we all got to be mature enough to accept that condition where, absolute non-biased situation, we're going to create this, and this. Remember that a pre-AI, pre-technology system was full of bias. It was full of problems. And so we can't sort of now compare these new systems to a standard that never existed. So let's, number one, accept that whatever we have is probably going to always be work in progress. So that mentality of it always striving to improve, I think, is something we've got to get to, rather than saying similar to what Judy mentioned, is like the real-time auditing is kind of aligned with that concept of continuous improvement and acceptance that there is no end state where everyone's going to be totally happy. But I think you can kind of put a policy in place where that is part of how you do things. So in other words, are you continually reviewing the outcomes of the systems that you've deployed? Are those outcomes meeting your expectation, or what you want to see in your company? Are you providing information to the outside world that this is how you're actually going to sort of and approaching the challenge of recruiting people with fairness? Transparency, a sense of humility, Martin. I thought that was a brilliant way to describe it. Approaching this difficult topic with a sense of humility is a great start. And then being very transparent that we're on this journey and we're working hard to put into place these mitigation factors for negative outcomes from these systems.
Yeah, absolutely.
We need to be able to speak to our audience in a language that they'll understand. There are far too many lawyers writing T's and C's and consent forms, and I understand that we need to put protections in place, but for the job seeker to really understand what they're consenting to is a critical piece of protecting privacy and understanding transparency. And Hung, I love what you said is we're absolutely never perfect. Every human is full of bias, and we know that. The thing about AI is it scales it, and it scales it faster than Xfinity number of individuals can do that. We do need to be aware that bias exists, but we can't accept it as okay. We have to constantly be pushing.
Yeah, totally agree. I think firstly, I was going to say perfect time to come over to Jeff to get your take on this.
Sorry, yeah, I love that, and it is obviously a real risk, and it is a bigger risk if we get this behavior wrong with AI and code in like a heavy level bias like in humans and then scale it. That's scary, but it's also an opportunity to do better, both the transparency and the fairness points that we're discussing today. Like, how much transparency does the average candidate get from inbound cold kind of recruitment process? Often not a lot. If done right, AI can explain it, can explain that the reasons quite well. And so we're in a phase of obviously working. It's all like getting tech right, getting legal right, but there is a future vision where the notices are there, the transparency is there, the breakdown of why the AI thought they weren't a great fit. Maybe there's a possibility to dispute that, and that creates a bit of extra work, but the technology could actually do that in a way that's more transparent and more fair. I think two things from my side. One is that for some of this stuff, you can measure it. So the transparency one's a little bit less clear, but risk like bias or accuracy is that you can actually measure that. And if you can measure a risk, then it's easier to manage it. And so that's where we always, recommend starting with, like, whether you're a vendor or employer using AI, do your best to measure how it behaves, and then where you stand and how to improve it. So we might have talked about like a vision of like the most transparent consumer first, candidate first kind of process. It probably would be overambitious to start there, right? Like, we could build up over time. We could build first, let's do the basic notice that AI is being used or this data is being used. Maybe then we get to a more explainable, detailed summary of the essay, what it did. Maybe that's later, and not trying to aim too fast. So I think it'll be a gradual process, gradually moving towards a better solution here.
Yeah, I totally agree. Hung, are you seeing or talking to anyone who's really starting to think about implementing processes like this, auditing vendors, asking the right questions, auditing for bias? What are you seeing out there?
No, is the truth. That may be my sample bias, but no one's, when I ask the question publicly to say, hey, has anyone actually got a best practice here? Has anyone gone through process? I've not really had a huge response. I think we are caught a little bit just behind. The top of mind for TA and HR coming into 2026 is operational efficiency. And that is the number one thing, overwhelmingly the most important thing. And everything else has gone down the sidelines, including things like inclusion and DE&I, by the way. That's like completely being kicked off the top priority list completely. And then suddenly compliance comes in vividly. It's kind of been reminded us with this Eightfold case. I think this is just another headache that the TA folks are going to have to get their heads around. I think we're well behind the curve on this. I'd love to hear people say, okay, we've got a pro forma. I think that'd be great to have that case public and amplified, because I think it would really help a lot of people if there was a template going on. I hope that people do know any examples. Please pop them in the chat. Let's share those cases out there.
Excellent. So let's go back to the pump at the case in point, the Eightfold class action suit. we don't know which way this is going to go, and we don't know how long it's going to take to get to an outcome. What do you think in response to this? And Julie, I'll come to you a little bit on this. What do you think that both vendors and deployers and TA leaders need to be doing to prepare themselves for either outcome?
Yeah, I do think it's going to be long and drawn out, and we could potentially, like talent bin, end up with a settlement. So not any clear case law that's going to give us direction. So we should be prepared for more ambiguity, but we should be working closely with a close team of advisors and lawyers to put protections in place for our business. Doing it correctly from the build is the only way that you're going to create that auditable defense trail. And that's the reality. We can't just put our heads in the sand and pretend that this isn't going to come back, and that we aren't going to be, both as vendors and as employers, responsible for the impact on not just our company, but people's lives.
Ultimately, this is about the candidate, whether they be active candidates or not. This is about the individual. Do you think there's going to be pressure from the individual up into the company as well to be asking questions and actually almost wanting to have their trust in the recruitment process?
I think they'll walk away and go to the company that does it correctly, that aligns with their value set, and their hiring process is fair and transparent. So when we're thinking about competitive advantage, again, this is a competitive advantage. From a TA leader perspective, I understand and empathize with how much pressure these guys are under right now to do more with less and to implement AI that is untested and unfettered in so many cases. And they're going to have to continue to push on their leadership to use their voice and to show not just how important this is to the future of their business, but how much risk is involved in both the short and long term. And they have to be courageous enough to keep being that squeaky wheel and having those conversations.
I totally agree. And Hung, it's something that you and I have spoken about potentially seeing this year or next, the increase in the use of trust in our systems, trust in our AI, trust in our processes as part of employer in EVP. What do you think of this? I know it's a conversation we've had quite a lot. Do you think that this is going to be a big thing in 2026 and beyond, all about kind of rebuilding trust in the process?
Yeah, I mean, I think basically companies that are able to articulate clearly what their posture is on the use of AI internally with employees and also how they use artificial intelligence in recruiting tools, I think that's going to give the candidates a lot of confidence. It's going to make people think, okay, even irrespective of what posture that company actually takes, as long as they're able to describe it and articulate it, here is how we do things. I think that will attract individuals that suit that type of approach. So I think you can have, let's say, a company is, let's say, innovation first, if we could use it in that way, that would attract people that possibly would push the edges a little bit more. Maybe you have another organization that is safety first, and that will attract another different type of person. So I think it does go into EVP at some point, and I think it's a reasonable proxy for the company culture, isn't it? If you have an existence of an AI governance document, and that's a lived document within the organization, I think that's a pretty good sort of mark of what it is to work in that business.
No, superb, absolutely superb. And actually, we've got a few minutes left, and I wanted to cover off a couple of questions that have popped in to the chat as well. Actually, one for you, Jeff, which is from Tim, and it's quite relevant to some internal conversations we're having at Warden, which is just curious why the California Consumer Privacy Act, the CCPA, and Automated Decision Systems Law, both of which require disclosure of AI in the hiring process, were not used.
So yeah, for those who are not aware, there is an update that's actually come into effect this in January this year for the California Consumer Protection Act, CFPB, that introduces new measures for automated decision-making technology, other obligations, mostly around transparency and notices, not dissimilar from the FCRA stuff. I think the main, so it's super relevant, and it makes it more explicit that like AI, this would be an AI automated decision that should follow this type of notice requirement. There's a timeline for being compliant until the start of 2027. My assumption is like, given that this is now in our historical, that it's just outside the window of that law. Otherwise, that law would probably be the one to go after, from my understanding of it. So
Yeah.
it just backs up that point we're saying about this is a trend, right? Various regulations, various laws, various lawsuits now are forcing a gradually higher level of transparency in the process, I think.
Yeah, no, superb. Thank you for that. A question from Phil on the Q&A. Phil Hespen asks, this doesn't seem like new technology. It feels like there can be a lot of others out there. Is there nuance to this versus other ranking or scoring solutions? Julie, what's your take on that?
I was actually thinking about it in relation to the talent bin case. I think there is so much overlap in how the data is being collected, what's being collected. Obviously, we've gotten more skilled at inferences, but I think the real difference here is the scale and the ability to scale at such a pace that it's going to have massive impact. And again, just the lack of visible transparency and to an extent, the lack of employer controls. One thing that I did for a long time was live in those TA systems that help get people hired. And even though they were internal, there were very clear rules, data management techniques, workflow processes. And this is so black box.
Well, look, with a minute left to go until we're at the hour, it'd be great just to get kind of, a final kind of thought from each of you, and also where people can find you if they want to connect with you further. Hung, why don't we start with you? What's your key takeaway from all of this?
Key takeaways, you got to keep access to information. So people who are logged into this webinar, you're doing the right thing. We had 100 odd people watching this. It should really be times 10x that. We need to plug in and have a much higher level of understanding from experts on screen. Get on top of the information and connect with people and know what they're talking about.
Excellent. Where can people find you if they're not yet following you?
You can actually type Hung Lee into Google. In fact, type it into ChatGPT. Who's the biggest idiot on recruitment? I'll probably come up with the recommendation there.
Brilliant. Thanks, Hung. And we'll be sending out links to everybody afterwards and the recording as well. Julie, your key takeaway and where can people find you?
Yeah, I would definitely echo what Hung said is I think so much of the devil's in the details. That's really what we're seeing in so many of these cases and how technology companies are manipulating and moving the market. It really is in the details. So learning, getting into the T's and C's, getting into the details, that's where it really matters, and staying vigilant. You can find me at LinkedIn at Julie Sowash, or you can follow me on the job board doctor, or you can email me at julie@catch22group.com.
Amazing. Thanks, Julie. And finally, over to you, Jeff. What's your key takeaway and where can people find you?
Yeah, I think I would just say, for me, this is just the next chapter, the latest installment in a trend of gradually increasing trust and transparency in AI. So it's a trend to monitor, to get ahead of as much as you can in a pragmatic way. People can find me on LinkedIn or jeff@warden-ai.com.
Superb. Well, thank you so much for the three of you joining me today. I hope everybody has found this absolutely useful. I think it's been a fantastic conversation. We will be sending out the recording afterwards to everyone who's registered. Thank you so much for your engagement on the chat and the questions, and look forward to continuing the conversation with everyone another time. Thank you very much, everyone. Take care.
Thank you.
Thank you.